Good afternoon, everybody. This is Bonnie Vandermeulen, Training Coordinator for Wisconsin Facets. On behalf of our entire Wisconsin Facets staff, I'd like to thank you for joining us today. Our webinar today is entitled Navigating the IDEA Complaint Process. Our presenter for today's webinar is Anita Castro. Anita is a school administrative consultant at the Department of Public Instruction, serving on the Procedural Compliance Work Group and the IDEA State Complaint Investigations Work Group. She has been at the DPI since 2000, serving as the Assistant Director on the Special Education team for 10 of those years. Anita has 22 years of experience as a special education teacher. She has a master's degree in special education from the University of Wisconsin-Milwaukee and is certified as a director of special education. It's my pleasure to introduce to you today Anita Castro. Anita?
Good afternoon, and thank you for this opportunity to talk about our state complaint process. I'm going to focus primarily on two topics: the dispute resolution options that are available, and then in more detail about the IDEA state complaint process. So all students with disabilities are entitled to a free appropriate public education, and that's sometimes referred to in shorthand as FAPE, in the least restrictive environment. If a parent or an educator or some other advocate is having concerns or a dispute regarding special education procedures in a district or special education services, there are several dispute resolution options that can be pursued. We always recommend that a person begin by contacting the child's special education teacher, and that it's important to start with the person who is closest to the situation or to those who are directly involved with the concern. Also, contacting the district's director of special education is also another very effective method of solving disputes. You can also work with the child's school principal or the superintendent and even the school board. And these are particularly important folks to have involved if it is more of a personnel concern. It's always important to follow up any contacts that you make. Let's say you've made a phone call to the teacher and expressed concern, or to the director of special education. If you follow that up with an email, that provides a written documentation of your concern and the date on which you made that concern to the school district. And that can be really important information for a state complaint process. If you have a concern, you can always request an IEP team meeting to come together as a team to discuss your concerns. You can also request revisions to an IEP outside of an IEP team meeting if you're not changing the placement of the student. The Wisconsin Statewide Parent Educator Initiative has developed some communication option resources for parents and other family members. And at the top of this slide, you see it says WISPE resource, and that's underlined. That's actually a hyperlink to their page where you can find this resource as well as other resources. This is a great communication tool. It provides kind of a step-by-step questions and process that you can use as kind of those first steps at resolving a dispute. It's always good communication is always key when resolving concerns. So having open communication that is really the first step, and like I said, starting with the teacher and the director. Notice that WISPE also encourages to first talk with the people directly involved, such as the teacher, as soon as possible. You can request to schedule a meeting, whether it be face-to-face. And face-to-face meetings tend to be more effective than over the phone because, or even by email, because then you have the benefit of being able to see the person, they can see you. The tone, oftentimes in an email, tones are misunderstood, and so it's just always nice and helpful whenever communication can be face-to-face. WISBE recommends that at the start of the meeting, you begin with the positive, focusing on the student's strengths and on what's working well. And that kind of starts the meeting off on a positive note. And then secondly, identify concerns and be sure to use active listening to ask questions and restate what you believe you're hearing so that everybody is understanding the same thing. But what if your concerns are not fully resolved at the meeting? Well, you might want to request that you take a break, give yourself a little time to think, and others to have some breathing space, or perhaps calling somebody to get other advice. If you are confused or have a question and you feel like you need a little more assistance, you can always make a phone call. On the opposite side of this communication options for families resource is on this screen is a blank copy of different contacts that are then filled in by the local school district. So the local school district would fill in who is the student's special education teacher, who is the director of special education, what is their phone number and their email, and so on. And you can ask your district if they have this communication tool. Many districts do already have it completed for parents. If not, you can present the form to them and ask them to fill it out for you so that you have it as a resource. Or you could collect the information, perhaps using the school directory, so you have this information at your fingertips when you need it. Another option would be to contact a DPI consultant. Each district in the state has an assigned consultant, and each consultant has about 20 districts that each of us work with. And so we tend to monitor those districts through our procedural compliance self-assessment, and we receive most of the phone calls regarding that district. So if you were to call into the department, you would obviously get an office operations assistant that will answer the phone, and then you can say that you have a concern about a certain school district and you're wondering if you can speak to the consultant who works with that district, and then they will route the call to that consultant. When you're discussing your concern with that consultant, that's not considered a formal IDEA state complaint. In this instance, when you're having that phone conversation with the consultant, or perhaps it's an email, you can also send emails to the consultants. You're basically asking questions, expressing your concern. And then the consultant may ask you if it's okay that they share that information with the district, because we like to complete the loop so that the district is aware that there's been a concern voiced. It's not a formal complaint yet, but there's a concern. And sometimes just that discussion alone can help to resolve the issues. If you're still having concerns, if there's still a dispute about special education with your child's school, after you've tried resolving it with the teacher or with the director of special education, there are additional options that you can choose to pursue to resolve the dispute. And this chart shows some of those options moving from left to right. You see from IEP facilitation to due process hearings. And it's somewhat of a sequential, although it wouldn't have to be, process. But it's a good idea to start with a less adversarial option. And so that's why we always say start by trying to just have a better communication with the teacher and so on, and starting by having those discussions. But the IEP facilitation is really an early conflict resolution option. And it's a good idea to start with that and then move across the line there, moving from IEP facilitation all the way to due process hearing if you need to do that. Each of these types of resolution options would be its own presentation, so I'm just going to touch on them briefly and then focus more on the IDEA state complaint process. So the Wisconsin Special Education Mediation System is a fantastic system that was developed in our state, and it was actually founded in 1996 by a parent, Jan Sarek, who was very much involved in Facets. You may know of her, a special education director, Nisan Barlev, and a mediator, Eva Soika. And this collaboration among parents, special education directors, and mediators still exists as a part of this process. This is a cooperative way for resolving disputes, and it's actually a nationally recognized system. We've had great success with this system. Wisconsin families of children with disabilities and school districts either together or individually can request a facilitated IEP team meeting, mediation, or a facilitator for a resolution meeting from this system. And the Wisconsin Special Education Mediation System offers a list of trained impartial mediators and facilitators to be used during the process. This system is free and voluntary, and mediation is private and confidential. Requests for mediation are processed by Wisconsin Special Education Mediation System, and then a neutral dispute resolution professional is assigned to the case. The facilitated IEP team meeting is typically used when there's little conflict, but a neutral party would be helpful to ensure that IEP team members are heard and understood. WSEMS, which is the mediation system I was just talking about, offers these neutral professionals who are rostered mediators to help facilitate IEP team meetings. The facilitator helps IEP team participants maintain open and effective communication. They help keep track, make sure that the members of the meeting are keeping on task, and they help to facilitate the resolution of conflicts that may arise in the development of an IEP. As I said before, either the parent or the school district may request an IEP facilitation, and there is a form for doing that online. And again, if you click back on that link in the previous screen, you can get to those types of forms. The IEP facilitation form is available both in English and Spanish. Both parties have to agree to facilitation, and either party can withdraw from the agreement at any time. So then mediation is kind of the next step up, and this is a facilitated negotiation in which a third neutral party, a mediator, helps parties to resolve their disputes in a private setting. The mediator does not impose a decision on the parties as it is done in a due process hearing, but rather assists the parties to work together to identify issues, generate options, and create their own solutions. Because mediation is voluntary, either party or the mediator may end the process at any time. Discussions that occur during the mediation process are confidential. If the parties resolve the dispute or a portion of the dispute, the agreement is in writing and it's signed by both parties. So you can see that's a little bit more formal than the IEP, the facilitated IEP, which results in an IEP. In this case, this is a mediation agreement. The due process hearing, either the parent, the adult student, or the school district has the right to request a due process hearing whenever there is a dispute between the parent and the school district over the district's proposal or refusal to initiate or change the identification, the evaluation, the proposed IEP or portion thereof, the implementation of the IEP, the educational placement, or the provision of a free appropriate public education. A hearing is requested by sending a letter or a completed request form, which the link is there on the slide. And again, that's also available in Spanish. When a hearing is requested, the department, by contract with the Division of Hearings and Appeals, appoints an impartial hearing officer, who is a judge, to conduct the hearing and sends the parent a notice of the procedural safeguards and a list of free or low-cost legal and other relevant services available in their areas. Attorneys are typically involved in due process hearings, and evidence is presented to the judge. So this is a little bit more formal process. And as I said, attorneys are often involved, so there can be some costs involved in this. So I want to spend more time today focusing on the IDEA state complaint, the Individuals with Disabilities Education Act state complaint process. Any individual or organization may file a complaint with the Department of Public Instruction if they believe a public agency or school district has violated state requirements under state or federal special education requirements. The complainant must allege a violation that occurred not more than 1 year prior to the date that the complaint is received. The party filing the complaint must forward a copy of the complaint to the district serving the child at the same time the party files the complaint with DPI. Notice that the complaint must be in writing and it must be signed by the complainant. So that's one of the differences that I mentioned previously. When you just call the department and you're talking about concerns over the phone, that's not the same as an official IDEA state complaint, because the state complaint has to be in writing and signed by the complainant. The complaint must also include a statement that the school district has violated special education law. It includes the facts on which the statement is based, the contact information for the complainant, and if the complaint alleges a violation with respect to a specific child, then it would include the name of the child's residence, address, the name of the school that the student attends, a description of the nature of the problem, including the facts related to the problem, and a proposed resolution of the problem to the extent that the complainant knows and available to the party at the time that the complaint is filed. And we have a form, the department has a form on our website that can be used for filing a complaint. And I have provided the link there on the screen and in the handout that you have attached. So we have the form both in English and in Spanish. The complainant is not required to use this form, but it does help to ensure that all of the information is provided. A copy of a complaint then is sent to the department, and it's addressed to the Assistant State Superintendent, Division for Learning Support. And you can see the address is in the corner there of the form. It actually says director right now, but on the website, when you click on the Model IDEA State Complaint Form website, you'll see that it actually goes to our Assistant State Superintendent, Barb Van Haren. So after the party filing the complaint submits the complaint to DPI, then you forward, I'm sorry, Bonnie, I'm not sure why that keeps beeping. I don't think I'm doing anything on my end, but I'll just continue on. Hopefully it's not.
Go ahead, please. Thank
Okay.
you.
Mm-hmm. So after the complaint is filed with the department, as I said before, the complaint also needs to be forwarded by the complainant to the district so that they are aware that the complaint has been made. Our complaint coordinator, and that is Marge Rassan at the time, reads through the complaint when she receives it and identifies any issues that can be investigated. And I'll talk a little bit more about the types of issues. They have to be specifically in relationship to special education law, whether that be state law or federal law. And then she assigns an investigator at the department to investigate the complaint. We have about a dozen complaint investigators on our special education team at the Department of Public Instruction. And we meet as a work group every week to discuss complaints and to receive our assignments. Then an acknowledgement letter is prepared by Marge Risson. And in the letter, DPI provides the school district or other LEA with the opportunity to respond to the complaint by proposing a resolution of the complaint and by agreeing with the parent who filed the complaint to voluntarily engage in mediation. The department must investigate a complaint and issue a written decision within 60 days of receiving the complaint. So when we receive it, it is date stamped, and that begins the 60-day timeline, and that includes weekends in the 60 days. The department can take longer than 60 days for exceptional circumstances such as the parent and school district agreeing to an extension in order to participate in mediation. So in the acknowledgement letter that goes out, and it goes out both to the district and to the complainant, in that letter, the issues are specified, and usually they're dot pointed and they're specific to special education law. It includes the date that the complaint was received, who filed it. Like I said, the issues are identified. It names who the investigator will be, and a request for documentation is made at that time so that the district can pull together the documentation and send it to the investigator to be reviewed. The parent also, or I should say the complainant, can also submit additional information if they would like to, if they have additional information that they didn't provide at the time of filing the complaint. So then the complaint investigator begins to review the complaint, and I'm one of the complaint investigators, as Bonnie mentioned. So we receive the complaint, we read through it and any attached documents that may have been included, and then we receive the documentation from the district. This usually includes things like the IEP, maybe multiple IEPs, behavior intervention plans, and other information like that. The investigator reviews the documentation and determines who needs to be interviewed. Usually the complainant is interviewed by phone, and then also district staff persons are interviewed. Typically, we interview the complainant separately and then district staff separately. The calls usually last about an hour, although it can be more than that. And sometimes multiple calls are needed. Sometimes follow-up information is needed. We're pretty good about meeting our 60-day timeline. I think in the last probably 10 years, we haven't missed our 60-day timeline more than just a few times. So we're very good about adhering to that. And we have an excellent investigation team to be able to complete our investigations in a timely manner. On occasion, an investigator may need to visit the school site. This is more often the case when there is seclusion involved and we need to see the seclusion room to make sure that it fits the specifications. Then once we've reviewed all the documentation that's come in, then we look at the applicable state and federal special education law in relationship to the facts of the case to determine if there's been a violation. Then the consultant drafts a complaint decision, and the decision includes the issues, the facts of the case, the related state or federal law, and the application of the law to the facts. We also identify in the decision as to whether or not there's been a violation of one of the requirements. Once the draft of the decision is developed, it's then submitted for review by the complaint coordinator. So Marge begins her review, and then from there it goes to our assistant director, in this case Patricia Williams has oversight of the state complaint process, and then it goes to our director of special education, Julia Hartwig, and then lastly to our division assistant state superintendent, who is Barb Van Haren at this time. And Barb then signs the complaint. If there are no violations, the complaint is closed at that point. If there are violations, the district is directed within a certain time period to correct any student-specific errors and also to submit a corrective action plan if there are district-wide errors that need to be corrected to ensure correction. The complainant and the district each receive a copy of the complaint decision, and the decision is considered final for state complaint process. The issues may be addressed through other dispute resolutions, including mediation and due process hearing. So if there is a violation, then the consultant who drafted the decision follows the case until the district has corrected and any of the identified noncompliance and submitted supporting documentation to verify correction. So I mentioned that there may be student-specific errors or there may be district-wide. So if there's a student-specific correction, that may be something like requiring the district to reconvene the student's IEP team to review and revise the IEP. So that would be an example of a student-specific correction. District-wide corrections tend to be more around training, so providing district-wide training on the errors that were found in the complaint so that those types of errors don't continue to occur in the district for other students in addition, beyond just the student who's the case was around. So after the district has completed their corrections, then they will submit examples of compliance checks, such as a copy of the student's IEP documenting the discussion that occurred at the IEP team meeting. Reviewing, sometimes we'll need to review additional student IEPs. So if it's a district-wide correction, we want to be sure that we're not seeing that type of an error in other students' IEPs. So we may request additional students' IEPs. If there's been training done, we may ask that the district provide agendas or a list of participants that have participated in that training. Once all the noncompliance is verified as corrected, and once we've received the documentation, the case is closed and a letter is issued to the district. The Office of Special Education Programs requires that all identified noncompliance be corrected within 1 year of the decision. Usually it's corrected well within that, usually 30 days for student-specific and maybe 90 days for district-wide. So although OSEP gives us a 1-year timeline, in Wisconsin, our complaint decisions are normally closed out within 30 to 90 days.
Anita, could you take a question on that?
Sure.
If you could go back to that back slide, the questioner wanted to know if the district is required to do a corrective action plan and they're starting in on it, how does the compliance division stay in touch with the family to let them know that, or let the family let the DPI know that things are going either okay or not so okay?
So if the district is working on their corrective action plan and it's a student-specific error, and the family is still involved in that situation, the family can contact the consultant who has been working on that case, who drafted the decision, to let the consultant know that there's still a concern. And we'll continue to work with the family and the district to get that resolved. So it's okay to contact the consultant again. Once the student-specific errors are corrected, and if the district is continuing to work on a district-wide correction, like I said, the training, providing training, and perhaps submitting IEPs, we typically do not continue any further communication with the parent because their issues are closed. The student-specific issues are closed. But if the parent has a concern or the complainant has a concern, before that the student-specific issues are closed out, then they can certainly contact the consultant, either by email or phone.
Thank you.
Mm-hmm. Most of our decisions are posted on the DPI website, and I provided the link there on the screen so that you can go and look at the complaints that are posted there. It is a searchable database, so it's very handy, and we've actually been commended on our website and the ability to search our complaint decisions. Not all states do that, so Wisconsin is unusual in that regard. The only exception is when the information is so specific so that someone might be able to figure out who the student is, or so we want to be sure to protect student confidentiality, and so we do redact all personal information from the complaint before it's posted, but still in some cases, even with all that information redacted, someone might be able to figure out who we're talking about. And so in a few instances, we don't post every complaint, but most of the complaints are posted. And so you can search it by topics. So like if you had a concern about your student in a school district, and you're wondering if anybody else has ever filed a complaint around that concern, you can go out to this database, type in a few keywords, and it'll pull up all of the complaints that have looked at that type of an issue previously. And it may be helpful to read through those complaints to get ideas about how those have been resolved in the past, or ideas about how to file a complaint.
Are you ready to take another question?
Sure.
The question says, can the IDEA state complaint process be used to address systemic violations? For example, a violation that impacts several students within a district. And how does such a complaint differ from ones filed on behalf of an individual student?
We have had complaints like that that have involved more than one student in a single complaint. And you would still fill out the complaint form in the same way, providing the information, and you would list all the students that you're concerned about. So yes, you can still file a state complaint even if it's regarding more than one student.
And then another question for you is, what if you decide to leave the district because it got so bad? Can a complaint still be made against the district so that it can prevent it from happening to other students in the future?
Yes, and we've had complaints like that, where a complaint is filed against the district where the student is no longer attending there, and we will still investigate the complaint. There just won't be opportunity for student-specific corrections because the student is no longer in the district, but there may be a need for district-wide corrections.
And one other, if that's okay with you.
Mm-hmm. Yes.
What happens if DPI receives multiple complaints from multiple parents around similar issues over a long period of time? In other words, when there appears to be a pattern or a practice that indicates a larger district-wide issue.
Mm-hmm. So we have a system of monitoring where districts are every 5 years receive monitoring, which is called procedural compliance self-assessment. And if a district has received a number of complaints, they may be advanced on that list and receive monitoring sooner than they would normally have been within the cycle. So that's one option that we have when we're determining which districts get moved up on that cycle. We consider the number of complaints that they've had and the types of issues and repetition of issues. We can also do what's called general supervision and take a closer look at a district outside of that monitoring cycle and process. So we have a number of procedures that we can follow if we see that there's a pattern of complaints.
Okay, thank you very much, Anita.
So some examples of issues if you were thinking about filing a complaint. As I said before, looking at our complaint website and using the database to put in your concerns to see if those types of issues have been investigated previously is one way to determine whether or not it's an issue that we can investigate. Looking at special education law, the Individuals with Disabilities Education Act, as well as our state law around special education to see the types of requirements that districts are required to fulfill is another way to determine whether or not your concern is something that we can investigate. These three topics tend to be very common types of errors, IEP implementation, and I've provided a link to a bulletin there that talks about IEP implementation and how to describe services in an IEP. We often will see that the description of services is not clear, so that staff are not able to implement the IEP because they don't understand what they're supposed to be implementing. So that bulletin helps to describe how to clearly document the amount and frequency, location, and duration of services so that everyone understands what is to be provided. Free appropriate public education is another example of an issue that we would investigate. Seclusion and restraint are also obviously issues that we investigate. As I mentioned previously, sometimes we even go on site when it's a seclusion issue. Types of services that, types of issues that we wouldn't typically, that we would not investigate would be issues like if a parent wanted a different special education teacher. Let's say they weren't happy with the teacher, there was a personality conflict, or they didn't trust the teacher. That's not something that we investigate. That would be something that the complainant should take directly to the school district and probably specifically to the school board if it's a personnel issue, or to the superintendent. Sometimes parents or others are not happy about a specific methodology, a teaching methodology that is being used with a student. They might want something like Wharton Gillingham, or some sort of specific way to teach reading, or a specific way to work on behavior. And we don't typically investigate those types of issues either. Those are more at the discretion of the district, and so that would be an issue that would be taken directly to the district. Around seclusion and restraint, what we sometimes might see is that they didn't use positive behavioral interventions and supports before the use of seclusion and restraint. We might see that they're not documenting the use of seclusion and restraint in an IEP, or that that seclusion and restraint is being used when the behavior was not a clear and imminent risk to the student or to others. Sometimes we see that no written report was prepared within 2 days after the incident, or that it was not accurately or completely prepared, or that the parent wasn't notified that the report was available, or that the seclusion or restraint even occurred. So those would be types of examples, and then examples that are not. issues. So lastly, I just wanted to provide a few resources here. So you have the Facets resource, WISPE, which I mentioned previously. There's Special Education in Plain Language, which is an excellent resource that is online that you can click on that link there and go to it, and then it's divided out by topics, and they have information about complaint procedures and other topics in that document that are very helpful. And here is my contact information as well as Marge Rassan, who is our complaint coordinator. And so if you have questions about the IDEA state complaint process, you can feel free to contact any of us. If you wanted to file a complaint, or if you wanted to discuss a concern, you could call the special education team, which the number is provided there on the screen, and you could discuss your issue. And again, if you wanted to file the formal complaint, then it would need to be in writing and signed, and you can use our complaint form to do so.
I do have another question for you.
Sure, go ahead.
I think this is pretty much a follow-up to one of the others. It says, do special education programs in schools receive the same procedural checks that are therefore monitored more rigorously than when they have multiple complaints, and that these multiple complaints are being filed regularly?
So are you asking, I want to repeat the question to be sure I'm understanding what's being asked. Are they asking that if a district is monitored more frequently, if there are more complaints filed in that district?
Right. I think that's what they're asking.
And it would depend on the circumstances. So as I mentioned previously, we look to see which districts to advance in our 5-year cycle. And one of the pieces of information that we look at is the number and frequency of complaints and the issues in the complaints, and determine whether or not a district might need to be advanced on the schedule for monitoring. I know there have been instances where we've done general supervision in a district when there have been multiple complaints, in addition to the state complaint investigation. So those are the two instances I'm familiar with when we do additional general supervision and when we advance them on the monitoring cycle.
Okay, and I guess the questioner just emailed back and said that they were asking specifically about special education schools, such as, I believe, like the Wisconsin School for the Blind, or visually impaired, or I guess some of the specialty areas in special schools.
So I believe they are on the monitoring cycle as well. I would have to double check that to be sure. The cycle is posted on our website, so anyone can go out to our website and look at the procedural compliance self-assessment. And on that website, there are like 4 different buckets. And in the first bucket, it talks about preparation for the self-assessment. And on that page, there's a link to the cycle. And you can click on the cycle and see which districts are being monitored when. And you could look to see if the Wisconsin School for the Deaf or the Center for the Blind and Visually Impaired is on that cycle. I know I know they always get monitored. I can't recall for sure if they're in the cycle or if we do them separately. So I'm sorry, I can't say for sure, but you could check there and see if they're on the cycle. If they're not listed on the cycle, I know that we do monitor them, but they may just not be listed on the cycle.
And I would guess if this particular person had further comments, they might want to contact either you or Marge directly, right?
That would be fine. Mm-hmm.
Okay. So Anita, do you have any closing comments for us? Because I have no more questions at this time.
I just thank you for the opportunity to talk a little bit about dispute resolution and the complaint process. And if there are further questions, feel free to contact me either by email or phone, or to contact the special education team at the number there on the screen, 608-266-1781.
Okay, thank you very much. I greatly appreciate it, Anita. This concludes our webinar for today. I'd like to thank everybody for joining us. And again, Anita, thank you for your most informative presentation today. Please be reminded that Wisconsin Facets still has webinars available in the month of December, and that we have over 80 scheduled trainings and webinars for 2020. Please check our website and register for upcoming trainings that you may be interested in. And also please watch for the short evaluation coming your way. Thank you all for joining us today. And Anita, again, thank you very much for your presentation. Bye,
Thank
everybody.
you. My pleasure.
Bye. Thank you.
Bye-bye.